So, Andrew, I think the first area we wanted to discuss this morning was about child arrangements and how it's a lot more complex if you're dealing with a child with special needs, isn't it?
It is indeed, because as we discussed before, the separation, not only does it change the child's living and care situation, it also has a real effect on their mental health due to such adjustments. And that's why it's really important that you have a bespoke, tailored arrangement that works and supports the child, which is why it's so important to obtain advice from a specialist lawyer who can be proactive, vigilant, inquisitive, but also alert to signs of change. And that's really important, particularly where you're dealing with children with special educational needs.
No, absolutely. I mean, from my perspective, I think these issues have to be dealt with absolutely from the outset. There's no point in being partway through proceedings or negotiations and then raising these issues. Do you agree that they need to be raised from the outset?
Exactly. And it's important to remember what underlies, as it were, the spirit of the Children Act, that contact is for the benefit of the child, not the parent. So it's having that bespoke arrangement right at the beginning, and all parties recognizing what the real issues are in the case, which again, as I say, is important why one obtains specialist advice.
And that's quite difficult, isn't it, for a parent to maybe step back and think what's right for the child or what they want. And particularly in special needs cases, the sort of standard alternate weekend, half the holidays scenario, it's not really going to work in many cases, is it?
No, the sort of traditional approach, sadly, well, it doesn't work for children with special educational needs. One still sees cases where recommendations are being made that a child with special educational needs is effectively, sadly, dragged kicking and screaming to contact. And that has a real impact upon their mental health. And it's a situation that is not going to change.
Absolutely.
I was just going to say, it's important to remember that it has to be a bespoke arrangement that works and fits in with what the child's needs are, and not fitting around the arrangements for the parent. And that can be very difficult because obviously when parties separate, there are two households operating and there are substantial changes going on within the carers' lives. But the priority has to be the welfare of the child. That's what the court is required to look at when making these decisions.
Absolutely. And what I'm finding is that we always try to negotiate child arrangements, either, through correspondence or encourage parties to go to mediation. But sadly, what I'm finding in cases with children with special needs is there isn't that awareness. And the proposals that are being put forward to us are just basically in ignorance of the fact that these children have additional needs. And there's a lot of arrangements coming forth about swapping weekends, half of the holidays, going back and forth between households. And it just simply is an approach that's untenable, isn't it? It's just not child focused.
That again highlights that legal advisors are not familiar with these issues, are not aware of the effects of these conditions upon children and their specific needs. And for example, one can fully understand that often the non-resident parent feels frustrated, or that there's a lack of progress along the traditional route. But it's important to remember for a child with special education needs that in fact, shorter periods of contact, which
Yeah.
are quality contact, positive contact, that is what is important, rather than I have to have half the school holidays, I have to have a minimum of 3 hours. It's what works for the child. And whilst in some cases, if one compares it with the traditional, half of all school holidays, alternate weekends, and possibly a Wednesday overnight or a Wednesday for tea, as I say, there may be this feeling of that it's a step back, but it's important that shorter periods, possibly less frequent contact, but a positive contact. Because what we do know from the research that's out there is that these children do remember
Yes,
contacts which are not positive, which do
absolutely.
cause them anxiety, and do sadly, in a lot of cases, have a detrimental impact upon their mental health.
Absolutely. I always say to clients that it's got to be at the child's pace and you're better off going slowly and it being positive and building it up gradually rather than pushing contact too fast and there being, a negative reaction from the child. But as you said, it's very difficult for the non-resident parent, understandably, to accept that. Perhaps when there's situations around them where they're seeing, shared care arrangements, alternate weekend contact, as you said, half the holidays, a Wednesday evening, it is a very difficult thing often for them to accept. So I do have a great deal of sympathy for that position also.
And you're absolutely right. For example, shared care, that's less likely in cases I see often in special educational needs cases because, put simply, the child can't cope.
No,
And I always say it's important for parents to understand the effect of special educational needs on a child. And it's gaining that information, that insight into what their child needs and being able to accept that. And as I say, to tailor arrangements around the child, because at the end of the day, that will provide the child with the most positive contact and also for the parent.
absolutely. I mean, I personally think for equal shared care arrangements, the parties have very similar outlooks, parenting styles. They have to have very good communication between each other so that the child doesn't suffer. But that transitioning for a child with any level of special needs, it's near on impossible, isn't it? To be in one household for 1 week or part of the week and then swap to another. It's just not familiar for them, is it?
No, and it's incredibly difficult for them to understand because of their needs, for them to be able to understand the social world around them is
Yeah.
very difficult. And that's why I say when parties separate, and it's quite often you have that the child has its safe space, not only in environment, but insofar as care is concerned. And
Yeah.
that's no criticism of the non-resident parent at all. It's just that usually one finds that one party will have effectively dedicated a huge
Yes.
amount of time and effort in supporting and what is
Mhm.
sometimes referred to as scaffolding in order to help the child as much as possible to achieve tasks which for children without special educational needs are very easy. But that is difficult for the non-resident parent to
Exactly.
accept. And it does cause problems until, hopefully you get to that stage where there is a recognition of the importance of a safe place, particularly for children who suffer with autism. They have their primary carer, they have their safe place. And the difficulty moving between properties, as you've highlighted, is very real for a child with special education needs. And often what one finds is that there's one property where all the needs are met. But then when you have the second household, it's not. And quite often, it may not be the non-resident parent's contact where the effect of that contact is actually witnessed.
Yeah.
Because quite often we can have masking with children, particularly those who have a diagnosis on autistic spectrum condition. And quite often the repercussions, which can be very significant, are only seen once the child returns to their primary placement.
Absolutely, because often we'll have the non-resident parents say, well, I never see that sort of behavior, therefore it doesn't exist. That's very difficult for both parties, but most importantly, the child whose needs aren't being recognized in that situation. And that's where we're talking about masking. Do you feel that amongst practitioners there's enough awareness about masking?
Sadly not. And not just within practitioners. I think it's fair to say that the courts and the Child and Family Court Advisory Service, or CAFCAS, that there are some colleagues who are still not aware of this because it is a difficult set of circumstances. Children can hide emotions, and with masking and indeed with internalization. And that's why I always say in cases where is dealing with children with special education needs, it's really important not to assume that
Yes.
a child is coping with a change in their environment because one doesn't see these overt behaviors that one would typically associate with anxiety and stress. And
Yes.
one, as I say, for example, children can withdraw socially, can become frozen or numb or wanting to hide in small places, or one sees an increase in repetitive behaviors. These are all common features that you see with
Or
children.
lashing out. A lot of my clients will say they come back from contact and they're lashing out to me. They're very angry and frustrated because they're unable to verbalize and process that emotion. So looking at it from the other side of the non-resident parent, it's so difficult for them as well because they just want to have a meaningful, extensive relationship with their child, which often isn't possible. And some of the cases that we've dealt, sometimes the non-resident parent will say, well, I'm not making any assumptions as to whether that's the mother or the father here, but more likely than not, it may be the father, may feel that they have no input. They may feel they have no control. They may feel they're losing their relationship with their child. What would be your best advice in respect of that?
I think it is a very difficult situation for the non-resident parent because they often feel shut out. And I think that's why it's important that where you have a child with special educational needs, and it may be that they have already had a formal psychological assessment, or there is special educational needs supports in place through
Yeah,
their educational provider, or we have an education, health and care plan in place. It's important that parents gain as much knowledge of the special needs that their child has in order to recognize and work with the primary carer. Because at the end of the day, what is important, and particularly with children with special educational needs, is an agreed co-parenting plan
absolutely.
so that routines are effectively identical, because it's all about reducing anxiety, reducing stress for the child. And whilst, as I say, it may be that contact does take longer to progress, both in frequency and duration, but with a shared parenting approach. And I often find that, for example, specialist parenting courses for children with ASC diagnosis can be really helpful
Mm,
because it increases a party's knowledge, but not only that, it increases acceptance. So they accept the situation that they're in. Their child is unique, and they have to
absolutely.
tailor their parenting around that. And by investing in that, they will ensure that their child has as positive a contact arrangement or a living arrangement with their parents, bearing in mind the specific special educational needs that they have.
Absolutely. And I think it's very important that the resident parent engages and involves the non-resident parent in things like assessments, in meetings. It's important that they are involved and they do have parental responsibility. Andrew, could you explain very simply what parental responsibility is and how this is such a feature in cases such as this?
Responsibility is very important. It's the right of any parent to be consulted about important decisions in their child's upbringing, put simply.
Yeah,
And those sorts of decisions are welfare decisions, health decisions, education, and religion. So all the really important decisions that one has to look at as part of a child's upbringing. And again, as I say, both for the resident parent, it's important that the non-resident parent is involved and consulted about those important decisions because they will feel invested in their child's upbringing, despite the fact that the parties themselves have separated. Similarly, again, for the non-resident parent, it's important to be involved because they need to know what supports their children need. And often in these cases, assessments are really important because changes are very difficult for children to cope with. And one has to look at transitioning arrangements in particular, supports, scaffolding, as I mentioned earlier, which can be put into place, which will be able to develop the amount of time a child spends with a non-resident parent as much as possible. But they have to be involved in those sorts of decisions. Otherwise, the difficulty is that the non-resident parent is more questioning of the resident parent. And one often hears arguments, oh, well, they're exaggerating the child's condition. It's not as bad as that at all. That's where it's important that there's an agreed approach. So if necessary for a psychological report, or if not for a psychological report, but both parties are involved in an application for an education, health and care plan assessment.
but really, I think the point that we also need to emphasize here is that if the other party does have parental responsibility, and even in the rare cases, then they wouldn't, you should be seeking consent and engaging the other party when it comes to any form of assessment for the child, shouldn't they?
Oh, it's vitally important. They have a right to be consulted. They have parental responsibility. And it is important that they're involved in the selection, the decision-making process, and also that they're aware of what the assessment process itself is as well. because again, it's all about informing the parent. They feel as though they're having their rights respected, that they're involved in the assessment of their child, which means that the acceptance, which is so important in these cases of special educational needs, is more likely, which can then hopefully lead to an agreed way forward rather than the need of having to approach the courts.
No, absolutely. And I think many cases, particularly with the pressure on CAMS, where people are having private assessments, and that can lead to one party then being willing potentially to fund half of the report, which are often significant sums of money, aren't they?
Indeed, and it is important because, as we know, with the pressures on the system, we're still in the relatively early stages of coming out of the pandemic. And that has had a real impact upon, in particular, children who have special educational needs. The waiting times for assessments, for example, in respect of ASC assessments, in some areas, one is looking at 2 years plus. And the number of pupils in UK schools with special educational needs in last year, in 2022, increased by nearly 1.5 million, which was a huge figure. And it's the highest recorded rate since 2014. And as
Yeah.
I say, the importance, and that is why parents, and they can't be criticised for seeking private assessments, because obviously they want their child to be supported as quickly as possible, and having to wait 2 years is just too long. But again, it's important that there is an agreed way forward and that both parents are involved as to what sort of expert one is looking for, the identity, and indeed their instruction, so that they feel fully invested in their child's future.
Absolutely. I mean, and the pressure on the resident parent is immense. And actually, if parties can get to a point where there is an element of co-parenting, albeit not in the traditional sense, perhaps, then it can be a source of support for the resident parent, but also the child. Life is uncertain, and for the child to have a strong connection to the non-resident parent and have that stability, it's got to be very when the child has special needs.
You're absolutely right, Rita. One of the big concerns I often hear from parents, particularly when separation arises, is, well, what's going to happen?
Yeah.
Because the single routine that both parents were involved in when the parties were together will change. And
Yes.
it's the consequences, not necessarily just financial consequences, but it's the practical support. Would one parent take the child to school in the morning, one pick up, or if not, for example, to an after school club or something like that? And these are real worries for the parents. And similarly, for the non-resident parent, it's, well, how is this going to work going forward? I'm not going to be involved. I'm not going to be on hand. And it's the effect that that will have on the child. And also, as I say, in the middle of it all, you've got the most important person, which is the child themselves. And that's why, as I say, it's a very difficult balancing exercise. And it's where you have to really think creatively and outside of the box as to how you can tailor a child arrangements order that will balance these competing concerns, but more importantly, needs, particularly where you're dealing with children with special educational needs.
So often we as lawyers, we're writing letters to other parties trying to highlight these concerns and reach child arrangements outside of the court process. And it's often not possible. And then we're suggesting that they go to mediation. Do you feel that amongst mediators, there is enough awareness of these issues? Because I've had slightly mixed feedback from clients.
I think my experience would echo yours. There are those who are very invested, are very aware of the issues where you have children with special educational needs, and are very invested in that, and effectively themselves can help in that educational provision of information to
Yes.
bring parties together.
Yes.
However, you still come across, should we say, the more traditional approach where they feel, oh, well, these are young children and alternate weekends and half of all school holidays, which completely ignores the issue. In those circumstances, sadly, mediation is bound to fail.
And actually, I think that can be quite damaging for the child, particularly in the parties' relationship, because it does mindset parties slightly, doesn't it? And then you're working quite hard to make them look at things in a different way.
It does. And they start from the premise that there's a fundamental lack of acceptance of the circumstances. There's a fundamental disagreement. One parent will say the child doesn't have a condition and therefore the traditional approach to contact is the way forward. And you have the primary carer who's actually looking after the child on a day-to-day basis, who's having to manage the huge fallout that there can be from these arrangements. Because the difficulty is these sorts of conditions, they're not the sort of conditions that can just be fixed.
No,
It's a
absolutely.
question of managing and supporting. And that is key, because it's all about helping the child reduce their own internal levels of anxiety,
Mm,
which are caused by their special educational need.
absolutely. Absolutely. And, presumably in lots of cases, as particularly we're working on, correspondence hasn't led to arrangements, mediation hasn't, and we're then in the court process. So, from your perspective, how would you say you need to highlight these needs, the child's individual needs, to the court right from the outset?
Well, it's very important to set out clearly for the court what the issues are. And in fact, as lawyers, it's the preparation which is key.
Yeah.
So in these sorts of cases, you're looking at, well, what evidence have we got before we get to the court? Has there been a formal diagnosis? If not, has there been, for example, a special educational needs provision within an educational setting? Or, for example, has there been, as I mentioned before, an education, health, and care plan assessment? Because that's a multidisciplinary assessment which covers a number of areas: psychological, education, social, and can often be a goldmine of information in these sorts of cases, in highlighting what the issues are, but in particular highlighting the supports to ensure that the child is able to cope with changes in environment,
Yeah.
changes in personnel. If any of that information is together, then obviously you want to highlight that at the very beginning for the court. Obviously, at a first hearing, there will be a CAFCAS officer, which is the Court and Family Court Advisory Service officer. I think it's fair to say the majority of CAFCAS officers I come across these days are well aware of the
Positive.
importance of recognizing special educational needs. And the judges who are allocated, again, the majority are aware of these issues now because it's involved as part of their annual training. But there are still those who take a somewhat more traditional approach, which is why it's important to make sure that you set out your position very early on with as much information you've got, but also looking at the case management stage, which will come along next. So if there are gaps in the evidence, what do
Yes.
we need to do to identify the best child arrangements ordered for this child? And that's where a case where you have a child with special educational needs has to be tailored. And you may be looking, for example, at occupational therapy reports or speech and language therapist reports in order to support children with sensory processing and things like that, all of which are part and parcel to ensuring
Yeah.
contact is positive and in the best interest of your child.
And what about cases which are before the magistrates? What is your experience about their level of awareness? Or would you say that these cases need to always be dealt with by a judge?
I think in the majority of cases, it is preferable that the management of these cases is dealt with by a district judge. Sadly, I've observed at times a total lack of understanding in the family proceedings court of the genuine challenges faced, particularly by primary carers of children with special needs.
Mm.
And as I've said before, I've even seen CAFCAS officers recommend an autistic child whose whole world is reliant on routine and consistently be quite literally dragged out of their home kicking and screaming for contact with the other parent. Or similarly, one has seen judges demand primary carers with special needs secure full-time work. I'm pleased to say these are getting fewer, but they
Mm.
are still there. What can often be helpful is if you have a very experienced and knowledgeable CAFCAS officer, particularly within the family proceedings court, because they can have a huge influence over the bench. If they have an in-depth knowledge of the impact of special educational needs on children, that can have a very important part to play in the process.
Because if we touched on reports and assessments, which I think would be of interest to lots of people, they can often be quite complex evidence and reports that then become part of the proceedings, can't they?
They can indeed, and particularly in these sorts of cases where one is dealing with children with special education needs, they can be critical documents. because they will set out the specific needs of the child, but they will also help guide the court in its assessment of what is the right approach to a child arrangements order for this child. And for example, it may say that, often I've had psychologists who will question, well, is there really a need to even try this form of contact because we know the child won't be able to cope? And it's got to be, as I've said before, probably shorter periods of contact in a very familiar environment for a child. Even, for example, a child with autism, even an hour in a room without their primary carer can be a massive step forward.
Absolutely.
Which one is, looking at the traditional approach, would be seen effectively as a step backwards.
No, absolutely. And a huge amount of patience is required. But the sorts of reports that we're looking at, you've touched on occupational therapist reports. We've talked about speech and language therapy. There's also then psychological assessments. Can they ever involve the parents?
They can indeed. And in fact, assessments, as I said before, in these cases are hugely important. For example, psychological assessments can look at a range of issues from mental health to psychological impact of a particular condition, but they can also look at the ability of a parent to provide the support.
Yes.
And whether there's any work that they need to do in able to make their parenting as good as it can be to support their child. And also these reports are very important if you're looking at support that a parent would need in order to care for a child alone.
Yes.
Which is often a huge worry, particularly to the primary carer. And as I say, it's especially important where a child has special needs or a medical condition, and the parent needs to be supported through that.
And I think if there is a child, for example, with physical disabilities and there's reports available, they really do need to be before the court, don't they? So the court need to have a complete picture of the child's needs, as does the CAFCAS officer if they're invited to write a report.
Indeed, because often these reports as well can address, for example, the placement for a child with additional needs, and to offer a view, as I said before, on the ability of different carers to meet the child's needs, as well as the support that they or should be put in place or provided for both the child and any carer. And that's really important for CAFCAS officers who are undertaking Section 7 reports or welfare reports, and also for the court as part of their determination when they have to look at what's in the best interest of the child, because one has to remember, it's the paramountcy of the child's welfare is the most important consideration for the court when dealing with these applications.
Absolutely. Well, thank you, Andrew. That's a really good overview of the sorts of criteria and circumstances that we need to factor into these cases. Thank you very much.
Thank you.
We'll be back in a moment.